Good day. First, I would like to thank our speaker, Mr. Lem Magaling, from the National Privacy Commission for explaining Republic Act 10173, otherwise known as the Data Privacy Act of 2012, and for clarifying some misconceptions about data privacy. To summarize, RA 10173 is aimed to protect the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. The Data Privacy Act is broadly applicable to individuals and legal entities that process personal information, with some exceptions. The law has extraterritorial application, applying not only to businesses with offices in the Philippines, but when equipment based in the Philippines is used for processing. The Act further applies to the processing of the personal information of Philippine citizens regardless of where they reside. Furthermore, the law states that the processing of personal data shall be allowed subject to adherence to the principles of transparency, legitimate purpose, and proportionality. What this means is that the collection of personal data must be declared, specified, and for a legitimate purpose, and further provides that consent is necessary prior to the collection of all personal data. It also requires that when obtaining consent, the data subject be informed about the extent and purpose of processing, and it specifically mentions whether it will be used for profiling or processing for direct marketing and data sharing. In addition, consent is further required for sharing information with affiliates or even mother companies. The law is tailored to protect the individual first and foremost. This might seem beneficial at the onset, but some sectors of the research and information technology sector view this as an added layer of bureaucracy that might hamper research and innovation initiatives in the country. At the very least, it discourages those who would want to do research because of the responsibilities and the possible legal liabilities attached to the collection of data. In my opinion, a more balanced application of the law will be better for both individuals and data driven companies. The National Privacy Commission should be more liberal in the application of the law. The law is clear and concise, but to the ordinary person, the application and relevance might not be so. Information campaigns should be intensified and test cases disseminated in order for the public to be more aware of their rights under the law. The Data Privacy Act, in my opinion, is definitely a step in the right direction. But unless the government actively educates and informs the ordinary citizen, it might just be another good law that nobody really cares or follows. Thank you.